Thank you for tuning in to the ongoing series Strawman Revealed, Part 3. In today's series, we'll be discussing the redemption process. I'm going to cut to the chase and get to the heart of the matter here today and discuss the rudiments of the system dealing with police, judges, and the legal system. Number 1, basis of action when confronted. Never walk into the police station or court voluntarily. Because if you do, you traverse and you acknowledge the validity of their jurisdiction over you. When you are confronted with an obligatory court appearance, keep in mind the following. Everything is commerce, contract, being administered in a state of emergency under the War Powers Act. The Commerce Clause of the Constitution operates in the private international law merchant of the bankers to whom essentially every government in the world is bankrupt. All of these functions in Admiralty Maritime where you have no rights and the captain's word is law. As a result of this condition, military war powers enforce all interstate commerce, which is everything, with draconian penalties for impeding commerce. Because the climate in which we live is a relentless and ravenous assault from all aspects of the government against our commercial liability, example, revenue raising, enforced by guns, violence, and prisons, life in America is a high-risk venture. In order to beat the system, it requires understanding how to neutralize the endless barrage of attacks in the form of commercial presentments or offers. Fighting is a no-win proposition. Matters must be neutralized, diffused, before victory can be accomplished. We have no money, only private paper money, insurance script like Monopoly, money or casino chips when a real monopoly has foisted on the world, operating in the bankruptcy. Everything is commerce, which is banking, which is debt paper, which is credit, debit balances, or bank books, which is bookkeeping. Assets or credits must always equal liabilities or debits. The books must always balance for world commerce to operate. The commercial account must be cleared within 3 days, which is codified in the U.S. in the Federal Truth in Lending Act, Title 12, United States Congress, Section 1601, Regulation Z. A traffic citation, summons, indictment, complaint, etc. is a commercial presentment. When the presentment is issued, a debt is created, a liability on the bank's books, which must be balanced with an asset. They want you to supply the asset in the form of paying a fine, some specific performance, or jail time. When you understand that every such commercial presentment is an offer to contract concerning which you have the following 5 options. Option number 1, you can deny or fight the charges and thereby traverse, join the action, legitimize their cause of action, and lock yourself in to their jurisdiction. This is a commercial dishonor. If you enter a plea or the judge enters one for you, you have traversed. The only issue now is the facts. Did you or did you not run the red light? In other words, dishonor submits you to a court proceeding to resolve the dispute over facts of the matter. Option number 2, you can demur. A demurrer accepts all alleged facts as true and raises of issues of law. A classic example is, yes, I did it, but so what? The statute of limitations has expired, so issues of law foreclose all possibility for me to be prosecuted in this matter. Option number 3, you can stand mute, in which both the law and facts are invoked. The judge will enter a plea for you and a court proceeding to resolve the controversy will commence. Standing mute is also commercial dishonor and locks you into both law and facts. Option number 4, you can protest, such as denying jurisdiction. This also locks you into the requirement to proceed with the court process to resolve the dispute. And option number 5, you can accept the offer or charges, citation, summons, complaint, indictment, etc. for value. Of all the options I've just mentioned, only number 5 diffuses, dissolves the controversy, thereby obviating all necessary or possibility for court proceedings. Since there is no dispute to resolve, you have agreed with your adversary quickly while you were on the way with him. And by accepting, it makes you the owner of the contract offer. And it also makes you the creditor. The creditor is always the winner in court proceedings, all of which have only two classes of participants, creditors and debtors. The debtor always loses and pays. And after you accept for value and own the contract or offer, the matter is non-negotiable.